Welcome back to the Community Law Training Course. This is a training course consisting of several parts to prepare you for the law. We've discussed the basics of legal research. Now it's time to discuss pre-litigation. Pre-litigation is concerned with getting as organized and prepared as possible before anybody files a lawsuit. This section discusses facts gathering, investigation, calculation of damages, legal analysis, and the demand letter. What is important here is understanding how a legal case develops and focusing on what is important so you do not waste yours or the court's time and resources. Consider an issue arises between person A and person B. Both have their sides. As is said, there's two sides to every story. Moreover, experience shows that the truth is likely somewhere in the middle. Then you throw in the law. The law cares about some of what each side has to say, but not all. After objections and everything else, only a small portion ends up becoming necessary and important to make a decision in your case. Your case needs to be focused on this. Here's more general information about this section, including the module's learning objectives. Welcome to the introduction to Module 2. Module 2 is concerned with pre-litigation. And in this section, we're going to cover the objectives. We're going to talk about facts gathering, investigation, calculation of damages, legal analysis, and the demand letter. The objectives for Module 2 are understanding which facts are relevant to your case, understand which laws are relevant to your case, understand the different types of damages available to you, understand how to perform a legal analysis and a case evaluation, and then understand the purpose of a demand letter and know how to write one. In the facts gathering section, we're going to talk about 5 different evidentiary objections. And when I say evidentiary objections, I mean 5 tools of evidence that is used to keep evidence in or out of a case. The first is relevance, and relevance is concerned with only the facts that are necessary to determine whether the law applies to your case and are allowed to be brought up in court. Nothing else, okay? Hearsay means that a statement was made outside of court, okay, and that statement was made by somebody else, and you're trying to prove that that's what was made in that statement is in fact the truth. And the person you're trying to use to prove that what was made in that statement was true is somebody other than the person who made the statement. An example is, my wife comes in and says, our daughter just puked all over the floor, okay? I don't know whether or not our daughter puked on the floor or not, okay? If you are trying to prove that our daughter puked on the floor, you would need to use my wife, who in fact saw her puke on the floor, in order for it to not be hearsay. Otherwise, there's no other way to prove that what my wife actually said was true. Meaning, you cannot use me to prove that my daughter actually puked on the floor just because my wife told me that that was the case. The third bit of evidence we're going to talk about is character evidence. You cannot use the fact that a person did something in the past to prove that they did a particular thing involved in your case, okay? Just because I hit a home run in Game 7 of a season does not mean I'm also going to hit a home run in Game 30 of a season. Just like just because I hit someone in a fight on July 30th doesn't mean that I also hit somebody in a fight on September 1st that is involving you or your case. Okay, so you can't use that. You could use it for other purposes, and we'll talk about that. Foundation, and this is what we talked about a little bit in the hearsay section, is you're not allowed to talk about any facts unless you're an expert that you have not used your senses to observe personally yourself. This means if you didn't hear it, smell it, taste it, touch it, feel it, or see it, then you cannot testify to it because you do not have personal knowledge that that fact is true. And finally, we're going to talk about authentication. And authentication deals with a person with personal knowledge being able to testify that a piece of evidence is in fact what you are claiming that evidence is. For instance, a contract. You cannot prove that a contract is the contract in your case unless you put someone on the stand who can testify that that contract is in fact the contract that is at issue in your case. Otherwise, that evidence does not come in. You do count as evidence, so you could testify to this fact. However, the point is evidence must be authenticated before it gets admitted. In the investigation stage, we're looking for information sources, all right? Where can you get information? And there's gonna be a number of sources that we're gonna talk about. We're gonna talk about people, businesses, doctors, counselors, and insurance places. This is obviously limited to privilege. Schools, extracurricular activities, social clubs and sports, banks, credit card companies, third-party creditors and lenders, etc. And we're also going to talk about waivers and how that's probably going to be necessary for you or a third party to get documents on your behalf from these various sources. But it's important to understand the mechanism of waivers and how that impacts your case. As we talk about calculation of damages, we're going to talk about the different types of damages available, who's responsible for which type of damage, how to calculate the different types of damages, and when to know this information and be able to exchange it with the other party. And this is important to know because obviously you want to make sure you have the right parties added to your lawsuit. You don't want to sue one party thinking that you can go after them for certain damages just to find out that you have the wrong party or the wrong type of damages. Or you don't want to end up missing out on damages that you would otherwise be entitled to. And so having this information is going to be necessary for your legal analysis. And legal analysis is concerned with gathering relevant facts, gathering applicable law. You break down the law into elements and factors, and then you use headings and subheadings to separate those elements and factors and organize them. And then under each heading, you put all the facts that apply to that particular heading or subheading. And then you organize the facts under each paragraph to tell a story for and against each position. This is you presenting your case as well as playing devil's advocate. That way you're prepared for what the other side plans to present against you. It's important you take this part seriously. And then you come to a conclusion based on the best application of the law and be able to explain why. You need to be objective here, because if you're not objective and you say, I win just because you're emotionally tied to winning, then that there's no point in doing this step. The point of this step is to prepare you for what is to come, and then maybe make any changes or differences in strategy that is necessary in order for you to win after you've gone through all of the facts, all the law, and then break those down and figure out how it's going to play out in your case. And then after your legal analysis, the point is to make this actionable. Okay, so you're not just going to do this step and then leave it. You're going to do a demand letter, and this demand letter is going to be sent to all liable parties. Again, this is why you should understand the damages, how much they are, and how you calculate them. You're going to provide an introduction to yourself. You're going to provide some background facts, why this is even coming up. You're going to provide some legal citations as to how they are legally liable. You're going to give a summary of your analysis, but you're not going to give away everything. You're not going to give away your entire strategy. but you're going to give away enough to let them understand that if they do this analysis, then they will lose. And because they will lose, you're demanding damages. And this demand needs to be clear, it needs to be easily understood, and it needs to be supported by your analysis. And then you need to talk about when to get the damages to you and what happens if they do not get those damages to you, or they do not respond to your letter. If you do not respond by this particular date and this particular time, I will be forced to file a lawsuit in the Superior Court of our local jurisdiction. And so that is, we'll cover all of the sections of the demand letter so that you should have clear expectations of where to go from there. Just so that you understand how to navigate where we're going, we're going to talk about the 5 different things. They're going to be covered in this order: facts gathering, investigation, calculation of damages, legal analysis, and then the demand letter. And then after that, you should understand your case enough to be prepared for litigation should you not be able to settle your case at the demand letter phase.